Aside from the previously discussed disclosures based on de-identification, limited data sets, authorization, and disclosures preparatory to research, there are other allowed uses and disclosures. A key concept here is that allowed does not always mean required. Some of the other uses and disclosures of PHI that are permitted under the privacy rule that have not already been discussed include the following. If it is required by law, for example, PHI may be disclosed to the federal government if it is required under a federal award. If the disclosure is to a public health authority for the purpose of preventing or controlling disease, injury, or disability. For example, PHI can be disclosed to NIH or the FDA if there was an adverse event. If the disclosure is to a person subject to the jurisdiction of the FDA with respect to an FDA-regulated product or activity, if the disclosure is related to a quality or safety issue, or is related to the effectiveness of the FDA-regulated product. For example, a covered entity may disclose adverse event or safety reports to sponsors of investigational new products. If the disclosure is to a health oversight agency for oversight activities authorized by law. For example, a covered entity may disclose PHI to the Office for Human Research Protections, or OHRP, for purposes of determining compliance with the Department of Health and Human Services Protection of Human Subjects regulations. You have reached the end of this submodule. Contact the Chief Privacy Officer at privacy@uvm.edu if you have any questions about other ways you may use PHI for your research.